Well, good morning. Welcome to everyone who is joining us this morning for our conversation on the historical, legal, and media contexts for the ongoing Wet'suwet'en conflict. My name is Coll Thrush. I'm Professor of History and Faculty Associate in Critical Indigenous Studies at the University of British Columbia, Vancouver, and I'll be moderating today's event. While the Wet'suwet'en situation has been overshadowed in recent weeks by the global pandemic, conflicting claims to responsibility for and authority over the Wet'suwet'en Yintah are not going away, and offer an opportunity for scholars, activists, and the general public to engage with the continuing realities of settler colonialism in Wet'suwet'en territories, British Columbia, Canada, and beyond. To begin today, I want to acknowledge that UBC Vancouver occupies the traditional, ancestral, and unceded territories of the Musqueam Nation. Their ongoing stewardship of this place benefits us all and reminds us that the so-called past is intrinsically imbricated with both present and future. We also want to thank the UBC Vancouver programs that organize this event: the First Nations House of Learning, the Office of Equity and Inclusion, and the Learning Circle. We extend a special thank you to Vicki George, a member of the Wet'suwet'en Nation and Assistant Director of the House of Learning, whose leadership and guidance made this event possible. Let me next briefly introduce today's speakers, who will each introduce themselves more fully, and then speak for 15 to 20 minutes before we open the floor to discussion and questions from viewers. First, Dr. Paige Raibmon is Professor of History at UBC, where she teaches courses in Indigenous and Settler Colonial History. Most recently, she is the co-author of Written as I Remember It, Teachings from the Life of a Slam and Elder. Dr. Gordon Christie is Professor at UBC's Allard School of Law, where he teaches courses on Indigenous and Canadian law. His writings have appeared in numerous law journals. And third, Dr. Candis Callison is Associate Professor in UBC's Graduate School of Journalism and the Institute for Critical Indigenous Studies. She's the co-author of Reckonings, Journalism's Limits and Possibilities, and author of How Climate Change Comes to Matter, The Communal Life of Facts. And I want to thank all three of you in advance for contributing to today's conversation. And I'll be moderating the conversation after the presentations. So let's go ahead and begin with Dr. Raibmon.
Thanks, Coll. Good morning, everyone. Thanks. Okay, next slide, please. Thanks. So, hi, everyone. Good morning. Thank you for being here. As Coll said, regardless of where each of us is physically today, as a UBC event, it's important to acknowledge the presence of UBC on the unceded and occupied territory of the Musqueam people. And I extend my gratitude to them as well for their stewardship and sharing of the land. We often hear that word, unceded, explained as meaning that the Musqueam have never ceded or surrendered their lands and waters that they've inhabited for millennia. And that certainly is true enough, but we could put it another way as well. We could say that the settler state has never acquired rightful title to these lands that it has occupied for the past century and a half. Next slide. And so putting it this way sounds a little different. It perhaps helps us to see just how astonishing it is, maybe a little bit absurd even, that the entire city of Vancouver sits on these unceded lands of not only the Musqueam, but the Squamish and the Tsleil-Waututh nations. Next slide. So as Coll said, my name is Paige Raveon. I'm a settler, and I've been an uninvited guest on these territories for most of my life, where I now work as a professor of history at UBC and where I'm raising my family. My own ancestors came to Canada from Hungary, Sweden, Poland, and the Russian shtetls. And one of my ancestors actually wrote about his immigrant experience in this memoir that some of you may know, because it's a little famous in Canadian history as a piece of immigrant literature. And it's about his life in Winnipeg's North End when he came from Hungary. Next slide. So I've benefited from the teachings of many people in my life, and I acknowledge some of those people here on this slide. But my words today are my own. Next slide. So in my comments today, I'm going to provide some historical context that I hope is helpful to understand the position that the Wet'suwet'en who oppose the Coastal GasLink pipeline are in. Now, historians like to say that history is the study of change over time, But in this case, and sadly, really, my story today is really one of continuity, lack of change. And I have two main points really to illustrate this continuity over time. And the first is that the actions by the Wet'suwet'en, who you see in this slide, for example, are part of an uninterrupted history of land defenders in British Columbia continuously asserting their rights to their territories that goes back to the earliest arrivals of Europeans here. Next slide. And my second point is expressed in this image. So I hope as you take it in, some of you are laughing a little bit at it. And its humor hinges in a way on its inversion of our assumption that land claims are made by Indigenous peoples and not by Europeans. And in fact, this is my other main point, however, I want to suggest that it is much more accurate to think about the Europeans or the settlers as the ones making a land claim. And furthermore, I want to suggest to us that the basis of that land claim by Europeans is exactly as presumptuous and ridiculous as this slide suggests. So next slide. And in fact, we could see this image as fair illustration of what is called the doctrine of discovery, a European legal justification for claiming Indigenous territories, not just in what we now call Canada, but around the globe. This is a doctrine that has since been repudiated by the international community, but it has not yet been entirely and thoroughly expunged from our judicial system and from legal thinking in this country. So this image, which we should find a little astonishing, is the de facto basis of the settler claim to the many Indigenous territories that we often gloss collectively as British Columbia today. Next slide. So this is the case because unlike a large part of the rest of Canada, the purple section in this map, British colonists, with few exceptions, did not sign treaties in the 19th century with Indigenous peoples in British Columbia, either before or after Confederation. Since the 1990s in British Columbia, there has been a modern treaty process underway. This has produced 5 signed treaties out of 65 negotiating tables. And I could add briefly that some of these other yellow parts in the map outside of BC have also since had modern treaties negotiated there. Next slide. So we could also call this map, at least with respect to British Columbia, a map of the doctrine of discovery. This basis of the settler claim has changed shockingly little over the last 150 years. Next slide. So this should be confusing to us, I think. We should wonder why. How has this been possible? Why is this still the case? And the extent to which this does not puzzle us, or we do not find it confusing, is a sign of how much we continue to take colonialism's premises for granted. So I'll try to explain some of the historical process here. Next slide, please. So these 3 men, or rather maybe the positions that these 3 men assumed as Governor of British Columbia, Commissioner of Lands and Works, and as a surveyor of Indian reserves, did a great deal in the case of British Columbia to set in place the circumstances on the ground that we have inherited today. James Douglas on the left did sign the few 19th century treaties that exist in British Columbia, but he then stopped. And he chose after that time, from the 1860s forward, to follow a policy of reserves instead of treaties. And reserves were part of an assimilation policy, which should also maybe give us pause and seem like a bit of an oxymoron to us. Douglas believed that Indigenous peoples could assimilate and become the same as Europeans by keeping them separate on reserves. It's weird. Next slide. So under these men, these 2 pieces of legislation in particular were key legal mechanisms through which they attempted to dispossess Indigenous peoples in practice, if not really in law, from their territories. So The piece of legislation, the 1860 Preemption Act in British Columbia, allowed newcomers to take up lands in British Columbia for a nominal fee, subject to them meeting certain nominal conditions. Indigenous peoples not only had their title or their ownership of the land denied by British Columbia, they were also barred from preempting land. So they could not even buy their own land if they wanted to after 1866. The second piece of legislation, the Federal Indian Act, regulated nearly every aspect of Indigenous peoples' lives, their identity. It worked to force their assimilation through banning cultural practices as well as banning Indigenous forms of governance. And in the place of those, it imposed band council governments on based on a foreign model of government upon Indigenous communities. Next slide. So through these legal mechanisms, among other things, the colonial state came to believe and assert that Indigenous territories that you can see in the top half of the slide here, which covered all of what we now call British Columbia, was somehow reduced to these tiny reserves in the image on the bottom. And I'm sorry for the poor quality of that lower slide, but those little black dots that you can just barely make out there, those are the size of the Indian reserves that were allocated to Indigenous peoples in British Columbia. Not as compensation for their territories, but not through negotiation, simply imposed upon them. And they were told, this is where you should now live. Next slide. Again, this should be confusing to us. How was this possible? And crucially for us, what did Indigenous peoples do? Next slide, please. So as I said at the outset, Indigenous peoples spoke up from the very beginning, and they did so in multiple ways. I won't read this whole slide, and just to emphasize, it's a very incomplete account, but they spoke up both with, not in multiple ways, through direct action, through petitions to the federal, provincial, and British governments. They sent delegations in person to Victoria, to Ottawa, to England. They appealed to the Privy Council, the highest court in the British Empire. And they formed together as nations to create organizations that could fight their land for land rights collectively. Next slide. This did not go unnoticed by the government. And in fact, the British Columbia government was so inundated with letters, complaints, and petitions, it published an entire book of them in 1876. So by then, it already had enough material to fill a book with Indigenous peoples writing in to explain that, in fact, their land rights were not being taken care of or recognized. We could also note from the title of this book, which all of you could actually now download for free on the internet, although that was certainly not the case historically for Indigenous peoples engaged in this struggle who fought simply to have access to this material. You'll notice that by 1876, the government was calling it the Indian land question. And again, I want to turn this on its head a little and suggest that for these generations of Indigenous land defenders, this looked a lot more like a settler land question, right? Which is how I tried to frame it at the beginning here. Next slide. So what I'd like to do now is try to introduce to you just a few of the individuals who I think it's important for us to know about and name where we can, who've been involved in this struggle. These people are really the ancestors of today's generation of land defenders. So next slide. I'm going to go quickly through these people. I'm not doing any of them real justice. The first person here is Latossin, or Clatossin, as his name is often anglicized, who led a group of land defenders who stopped surveyors from mapping a road through unceded Chilcotin territory that would have taken settlers and miners through to the Caribou Gold Rush. And he was executed, as some of you know, by the state for his actions. Next slide. There's a different strategy pursued by Arthur Wellington Claw, this man who traveled regularly from his home on the North Coast as a migrant laborer to Washington State and to visit his lawyer in Victoria, where he regularly checked on the land case that he was pursuing with respect to his territory. Next slide. Then there are these Salish chiefs dressed in their regalia, embarking with the rest of their entourage from Vancouver to go to England in 1906 to petition the King of England to address the land question in BC, and to declare that this was a nation-to-nation relationship that demanded the Crown directly get involved. Next slide. And although the official records and photos that we have take less note of them, women engaged in the land question too. So this is an image of Gathstelas, or Jane Constance Cook, who was a Kwagyouth woman. She worked as a translator at the testimonies of a government commission that investigated reserve size across the entire province between 1913 and 1916. And every time commissioners asked Indigenous community members to comment on their reserve size, they pretty much got the same answer. Why do you want to talk about reserves? We want to talk about title. We never asked for these reserves, and we certainly do not accept them as compensation for our displacement. Next slide. Now, in response to this commission's hearings, a collective organization formed called the Allied Tribes. And Jane Cook was the only woman on its executive. You could see her here in this slide. And the Allied Tribes carried their actions forward from their response to that Reserve Commission through the 1920s. In 1923, they brought their case they moved their case towards the Privy Council, hoping to build on recent helpful precedents elsewhere in the empire that had acknowledged Indigenous title. In 1926, the Allied Tribes wrote a petition to King George and delivered it to the High Commission in London. And in 1927, a joint committee of the Senate and the House of Commons in Ottawa agreed to hear their case directly, and also in so doing to divert it from that international arena where they were gaining attention. Next slide. And at those hearings, the evidence given by these two men in Ottawa in particular, longtime activists and members of the Allied Tribes, was particularly compelling and profoundly moving. On the left is Andy Paul, who'd been a longshoreman, an activist, a famous athlete and lacrosse player. And on the right is Peter Kelly, a Haida activist who was also a Methodist minister. Next slide. And this slide is a sample from that testimony when Peter Kelly was asked by the commission what they would do if they were turned down today after giving their entire testimony, which amounted to a title claim to British Columbia. I'll just read part of it. He said, "The Indians have no voice in the affairs of this country. They have not a solitary way of bringing anything before the Parliament, except as we have done this last year by petition, and it is a mighty hard thing. If we press for that, we are called agitators, troublemakers, when we try to get what we consider to be our rights. And perhaps if we are turned down now, it might be another century before a new generation will rise up and begin to press this claim." So in response to this, the committee did turn them down. And it then simultaneously, or shortly thereafter, moved, next slide, to try to make sure that it would be close to another century before Indigenous peoples could organize again. The same year, 1927, as the hearings in Ottawa, the federal government amended the Indian Act with Section 141 that made it illegal for Indigenous peoples in Canada to hire a lawyer, to pursue land games, or to organize for political purposes. So close on the heels of this testimony by the Allied Tribes, the government made it illegal for further claims of that nature to go forward. Now, the amendment did destroy public expressions of Indigenous rights, but it certainly did not kill the movement or the certainty that Indigenous peoples felt that this land remained theirs. Next slide. And this is particularly clear because when the amendment to the Indian Act was repealed in 1952, Indigenous peoples were ready and they renewed their pressure on government. This is a picture of Frank Calder, a Nisga'a man, also the first Indigenous person elected to the BC legislature. And the Nisga'a were among the first Indigenous peoples in BC to organize and advance their claim after the ban was lifted. Frank Calder's name was on the Nisga'a land title case, which was decided by the Supreme Court of Canada in 1973. And this was a huge victory, even though the Nisga'a didn't win. So it's a bit of a paradox. The case was a tie, but it was a victory because 6 of the 7 justices agreed for the first time in Canadian legal history that Indigenous peoples had held title to their land when Europeans arrived. Now, the judges, however, split on the decision of whether the arrival of the British had eliminated or somehow extinguished that Aboriginal title. 3 could find absolutely no evidence that Nisga'a title had been extinguished by British presence, and 3 thought somehow the British arrival must have extinguished it. And the 7th judge refused to rule on a technicality. So even as a hung decision, it set an incredibly important precedent that subsequent legal decisions have built upon in Canada. Now, and the Nisga'a advanced their claim on their own. Next slide. Other Indigenous peoples took a collective approach that harkened back to the Allied tribes. So this man is incredibly important in this respect. He's the Secwepemc politician and leader, and organizer, George Manuel, who the same year, incidentally, as the Nisga'a decision, the Calder case came down, published an incredible book that interweaves his own political philosophy with the history of Canada and with his personal experience. And Manuel was crucial. He served as president of the Union of BC Indian Chiefs, president of the National Indian Brotherhood, one of the first federal Indigenous organizations, and he was the founder of one of the earliest international Indigenous organizations, the World Council of Indigenous Peoples. So this makes 1973 quite a year for Indigenous peoples organizing in British Columbia. Next slide. And again, I'm not going to talk about these things, and you can see in the following decades that Indigenous peoples' actions across the province only exploded, and in a diversity of ways. Indigenous peoples worked collaboratively and on their own. They negotiated, they litigated, and they took direct action. Next slide. And so I'm not going to talk about really hardly any of these, except just here to point to Delgamuukw, because this is crucial for our topic today. The Delgamuukw decision from the Supreme Court was a decision that resulted from the Gitxsan and Wet'suwet'en chiefs jointly bringing their Aboriginal title case to the courts. And it was the first Aboriginal title case to go to court since Calder. And like Calder, it was a huge victory, even though they technically did not win a declaration of title for their community. After losing at an infamously racist trial, with a racist decision that dismissed Indigenous oral history and that valorized colonialism, that decision was overturned by the Supreme Court, which ruled that oral history must be admitted in courts, and in a decision that also set the first test in law for Aboriginal title. The Supreme Court did not apply this test to the Gitxsan and Wet'suwet'en, however, but urged government and the nations to save themselves another trial and to negotiate a fair settlement instead. And with 25 years plus having gone by, the government, we see, has not yet done so. So the inability of the government to address this crucial Supreme Court decision has led directly to the conflict with Coastal GasLink. The government has proceeded instead to grant licenses to companies to work in that unceded territory. And so just finally, next slide, I'm going to close with these words from George Manuel that I think remain, from 1973, that I think remain relevant for our conversation today. insofar especially as they urge us to see the big picture and to examine our own deepest assumptions about things. As he says, real recognition of Indigenous people's presence and humanity would require a genuine reconsideration of so many people's role in North American society that it would amount to a genuine leap of imagination. And I think I'm going to leave it there. Thanks so much, everyone.
Gordon, if you would like to take us over next. Please unmute yourself there.
I think I was unmuted by somebody else. Yes. I was just enjoying Paige's presentation. That was quite a long history condensed to just a few minutes. Thank you very much for that. So I'm going to shift gears a little bit. Oh, I was waiting for my first slide to come up. I didn't realize I had a blue background. Thank you. I'm going to focus on the legal context. So we'll shift from the historical context to the legal context. Now, as a matter of course, these two things are intertwined. So it's been great to have this historical picture set for us. The legal picture, purports to focus on legal doctrine, but the legal doctrine is interwoven with the history. But now with that history in hand, we can turn to what the law says. Next, please. And I'm attempting to present what is, I believe, almost entirely a fact-based analysis. I'm just going to look at the situation as it exists within the law. At times, the facts themselves are unsettled. So I'll point to those points where the law is unsettled, and so there's no fact you can point to and say the law says this. But there are many places where the law is relatively settled, and I'm going to focus on that framework. I'm going to walk us through the three legal systems that are in play right now in this situation. We have Canadian law, but we also have Wet'suwet'en legal and political authority. And I'm going to speak quite a bit about that. And then at the end of it, I'll turn a little bit to a speculative mode, because we have international law now entering the scene. We have a piece of BC legislation that came into being last fall. It isn't really operating on the ground right now, and so we're going to just talk for a few minutes about how it might play a role in perhaps pushing us forward a little bit in this situation. Next, please. So Canadian law, the fact of the matter is that the notion of crown sovereignty, the fact of crown sovereignty, is at the core of Canadian law. And I was looking at some of the questions that have appeared already in the chat section of this, and some people wanting about doctrine of discovery. I can try and say a little bit about this as we go along, but that doctrine is responsible for this fact that Canadian courts have always begun with the notion that crown sovereignty is the rock around which everything else spins or revolves. It is unquestioned in Canadian law, and it is the core of Canadian law as it applies to Aboriginal peoples. The court said this first in Sparrow, the first big case on Section 35 in 1990, and they've been saying this since. So it's important to begin with that. Now I'm talking now about Canadian law, and we'll get into other legal systems in a few minutes. But it's important to know that Canadian law rests upon the notion of crown sovereignty as being unquestionable. Now, I'm not going to say much more about Delgamo. Well, I'm going to say a bit more about him, not the detail that Paige just went through. I just want to note that this case in 1997, as you see, I've picked out from the head of the case, the plaintiffs. So the plaintiffs were individuals named. They're named in a schedule at the end of the decision, but they're actually on behalf. I'm not sure if I don't think I have an underline function here, but I would have, if I'd gone back and fixed this up, I would have underlined the last little bit of this, suing on their own behalf and on behalf of 38 Gitxsan houses and 12 Wet'suwet'en houses. So were the houses themselves that were actually the plaintiffs in this case. And this is a small point where there is some question about the status of Canadian law, because the Supreme Court of Canada never spoke directly about this matter. They accepted the plaintiffs as they came to them, but they never actually talked about the fact that the houses were the ones who were making the claim to title in this case. The strong implication, though, the very strong implication, though, is that because they didn't question this, that they acknowledged that the houses are, in fact, the title holders. They'd be the bodies that would hold a title to the territory. I think the chances of them going back and saying something different at this point in time were practically nil. So I think it's relatively settled in Canadian law that the houses are in fact the title holders under Canadian law. So as Paige mentioned, the Supreme Court developed Canadian law and Aboriginal title in this case. It's a foundational case in the area of Aboriginal title. And we only really have one other significant case in this area, and that's Chilcotin Nation from 2014. So we have two big cases on Aboriginal title. And as Paige mentioned, this was sent back to trial. And we also know that there's no treaty, either historically or a modern treaty, that covers Wet'suwet'en territory. So that's sort of the legal groundwork here for what we have before us. Next, please. Now, it was sent back to trial, this matter, in order for a Supreme Court or a lower court or some court in Canada to determine what the Aboriginal title would have been of the Wet'suwet'en and Gitxsan houses. But it's an interesting, this is an area that's unsettled. It's curious as to why that would have to be, because Section 35 of the Constitution Act of 1982 says simply this is it, the entire section. The existing Aboriginal treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. Now, if the Aboriginal rights of Aboriginal peoples in Canada are recognized and affirmed in 1982, it's unclear why you would have to go through this process of litigation in order to get your title established. Presumably, your title was recognized in 1982, speaking of Indigenous peoples across Canada. In Delgamo, the Supreme Court of Canada, when you get down to the details around Aboriginal title, they say that Aboriginal title comes into being across Canada at whatever point it makes sense to say that the Crown asserted sovereignty in that location. So in British Columbia, the Supreme Court of Canada in Delgamo and in other cases, suggested that the Treaty of Oregon would be the point in time where the British Crown, which became the Canadian Crown, asserted sovereignty. And so in 1846, Aboriginal title came into existence in British Columbia, and then later British Columbia became part of Canada. That would become Aboriginal title in Canada. And so again, the two points together indicate that Aboriginal title in Wet'suwet'en territory came into existence in 1846, and then it was recognized and affirmed in 1982. So it's a strange world where the Wet'suwet'en, for example, are now expected to go through this expensive process of litigation to do something that they shouldn't presumably have to do, but this is the nature of Canadian law. Next, please. Now, what happened after Delgamo is the Canadian governments, federal government and provincial governments across Canada, but in BC, the provincial government and the federal government, they both continued to act as though Aboriginal title didn't exist because the Wet'suwet'en hadn't achieved a finding of title in that case, and they didn't go back afterwards to a new trial, and they haven't negotiated a modern treaty. And so the provincial government in particular continued to act as though there is no such thing as Aboriginal title in this territory because it hadn't been established. And this was really the driving force behind the Haida Nation decision that came out in 2004, because this happened across the province. So the Haida, for example, were making claims around title at this time, and other people around Canada were making claims about title. But until Canadian courts recognized title, the position of the governments would be that no such thing existed. And so the governments in Canada, provincial government in BC, they continued to act as though there were no rights to deal with. And in Haida Nation, the Supreme Court of Canada developed the doctrine of asserted rights, saying that even in a situation where an Aboriginal people haven't established their rights, but they're claiming rights, there are still these obligations in the Crown. And as a result of that, we've had a major industry within the legal community around the duties to consult and accommodate that come out of these cases, the Haida Nation and Taka River Tlingit case. Now, okay, that's 2004, but since then, Canadian governments continue to act as though Aboriginal title doesn't really exist until established in Canadian law. And this is the situation on the ground in Wet'suwet'en territory today. The provincial government does not act as though the Wet'suwet'en have title, even though purportedly Aboriginal title has been recognized and affirmed in 1982. Next, please. Now, on top of that, Paige characterized Delgamo as a tremendous victory, and it is a tremendous victory in certain ways. I would say the first half is more or less a victory for the Wet'suwet'en and Gitxsan. The last third or so of the case, though, follows a pattern from the Supreme Court of Canada where they upfront the good parts and then they put the really bad parts at the end. And at the end of the decision in Delgamo, the court looked at the power of the Crown to infringe upon Aboriginal title. And so there's a long section in that case where they talk about how the Crown can justifiably infringe upon title. They set out what I would characterize as fairly onerous requirements for this. So the Crown does have to do certain things if it's going to justify infringing upon title. I would defend that characterization, fairly onerous. They're not really onerous because the fact of the matter is the Supreme Court of Canada said that Canadian governments can do all kinds of things that would be sufficiently compelling and substantial objectives that they'd have in mind in infringing title. The onerous part really is that in pursuing some objective in infringing upon title, the Crown has to act as a fiduciary. Now, what this means, I don't have time to get into the details. You can all apply to law school and take courses in this if you're interested. But it's where the onerous requirements come in, but they're still not particularly onerous. So just to jump ahead a little bit, imagine the Wet'suwet'en did go back and litigate this matter again, or they got into a modern treaty. At the end of the day, if they had title over the territory where the Coastal GasLink pipeline is going through, the provincial government could still pursue infringement of that title. And as long as they did so in the right kind of way, they probably could push ahead. So just, again, Canadian law is not something that actually functions in a way that protects Indigenous peoples. Next, please. So let's step back from Canadian law then, because so much of the discussion in the media has been about Canadian law, and we've had many Canadian politicians talk about the rule of law, including our premier. And the fact of the matter is, this is a fact-based analysis. The fact of the matter is that Indigenous legal and political authority has existed and continues to exist across much of Canada. Now, there are certainly places in Canada where the legal and political authority of Indigenous peoples has been undercut or perhaps even potentially removed, but that's not the case in the Wet'suwet'en territory and in most places or many places in British Columbia. And that is just a fact of the matter. So as much as people like to say otherwise, they're just trying to recreate the reality on the ground. And this authority, Indigenous legal and political authority, it continues to exist outside and alongside the legal and political authority claimed by the Crown. The authority of the Wet'suwet'en is not something that exists within the Crown and its sovereign authority. It's separate and independent from that. So the fact of the matter is, I like to use that word fact. The fact of the matter is we have in Wet'suwet'en territory two independent sources of legal and political authority. Next, please. So now let's expand our discussion of the legal context. We have Canadian law and Indigenous law. Going back to the status or the point of view adopted by Canadian governments and courts, they do not accept the facts that I laid out in the last screen. They do not accept that Indigenous legal and political authority continues to exist and that it runs alongside Crown sovereignty. In fact, it's pretty easy to look at the history of Crown activity in the last 30 or 40 years to see that they have continued to push for one of two things, either to simply have nobody talk about this, everybody ignore the fact there's Indigenous legal and political authority, or they're trying to take whatever authority they implicitly recognize and try and push it into Canadian law and politics. So we had a decision in 2001, for example, the Supreme Court of Canada, where the Supreme Court of Canada tried to argue, they tried to present the picture that whatever Indigenous legal and political authority exists, it's actually part of Crown sovereignty. And that doesn't happen unless Indigenous legal and political bodies accept that simple fact. Next, please. So now we have, in Canadian law, we have in the province this Declaration on the Rights of Indigenous Peoples Act that came into being last November. It's now part of the law in BC. And the question would be, does this signal some sort of a shift? Do we finally see something happening where a Canadian government is willing to acknowledge that Indigenous legal and political authority exists? I'm not going to go into an analysis of this act at this point in time. It's very short. If you Google this, you'll come up with this act very quickly. You can read it yourselves. It's something you'd read in 5 or 10 minutes. And the heart of it really is section 3. So I'll just point to that. It says that in consultation and cooperation with the Indigenous peoples in British Columbia, the government must take all measures necessary to ensure the laws of British Columbia are consistent with the declaration. And if I were to spend some time on this, I would unpack that and ask some questions about what impact this act is likely going to have. Just thinking about the pipeline, for example, imagine hypothetically that another pipeline is being proposed at this point in time through the same corridor. And I believe there are something like 10 or 11 pipelines, being proposed for this corridor through Wet'suwet'en territory. But just imagine another one that hasn't been approved at this point in time. Is there anything in this section that indicates that the BC government would actually think that the UN declaration means that they have to get the consent of the Wet'suwet'en for this other pipeline to go through? Well, the Act actually only speaks about ensuring the laws of British Columbia are consistent with the declaration. So those are the laws on the books. It doesn't actually talk about the decision-making capacity of the government, which is the government acting in what's known as its executive capacity, making decisions about whether to approve projects, for example. So it's open. We don't know. We don't know how this is going to play out, but the wording of the Act indicates that it's not clear at all that the government in British Columbia would actually have to get the consent of Indigenous peoples under this Act in order to move ahead with projects. So I'm going to leave it to the side now, because really this is the work of people in British Columbia the next 10 or 20 years to take this Act and try and make something of it. Let me shift to actually what the UN Declaration says. Next, please. So this is the declaration that BC laws are supposed to be brought into consistency with. And this is actually quite an interesting document. It's not entirely radical, but there are radical elements to it. And I'd like to just spend a few minutes walking through this and just imagine a world in which this act actually, or this declaration, really did come in a fulsome manner into Canadian law, or into Canada, where it would regulate Canadian law and Indigenous law in some fashion. So it's a pretty long declaration. Again, you can find it online easily. It doesn't take that long to read, but it does have 46 articles and a very long preamble. I've just selected out the pieces that speak most clearly to the kind of situation faced by the Wet'suwet'en. From the preamble, I picked one piece, and this speaks to, again, the question of the doctrine of discovery. So this affirms further that all doctrines, policies, and practices based on or advocating superior peoples or individuals on the basis of national origin, racial, religious, ethnic, or cultural differences that are racist, scientifically false, legally invalid, morally condemnable, and socially unjust. Okay, so it speaks about doctrines. The doctrine of discovery does in fact sit at the base of Canadian law as it applies to Aboriginal peoples. Again, I've seen a question where somebody asks about that, and afterwards I can talk about this. It's really indisputable that the doctrine of discovery is at the base, it's at the foundation of Canadian law as it applies to Aboriginal peoples. And it is based on the superiority of peoples on the basis of national origin, racial, religious, ethnic, or cultural differences. So the preamble speaks about countries around the world trying to distance themselves from these kinds of doctrines or policies. So if this declaration were to come into Canada in a manner which sort of questioned the status of Canadian law, this is how it would do it. It would actually require Canada to rethink the doctrine of discovery, because it is racist, scientifically false, legally invalid, and so on. So now going into the articles, again, there are many articles that touch on the kind of matter that's unfolding in the last 10 years or so in Wet'suwet'en territory. But let me just go through a couple of these quickly. Article 3, of course, is one that many people have heard of. They know that there is a right to self-determination that is articulated in the UN Declaration. So we see that Indigenous peoples have this right. It's, in a sense, many of the other articles come out of this notion that there's a right to self-determination that Indigenous peoples have. So here they speak of this right, allowing them to freely determine their political status and freely pursue their economic, social, and cultural development. Next, please. Let me focus on the articles that speak directly about that notion of self-determination as it relates to land or territory. So first we have Article 20 that just, again, digs into this notion of self-determination. Indigenous peoples have the right to maintain and develop their political, economic, and social systems or institutions. So thinking again of the Wet'suwet'en as having independent legal and political authority, it is being upheld in the UN Declaration. Indigenous peoples like the Wet'suwet'en have the right to maintain these institutions, their own institutions of law and politics. Article 26 then turns to land. We have in 26.1, Indigenous peoples' right to lands, territories, and resources they have traditionally owned, occupied, or otherwise used or acquired. The fact of the matter is, keeping to the facts again, that the Declaration does envision a different legal framework for Indigenous peoples within any part of the globe, but in particular within Canada, a different framework for Indigenous peoples within Canada than what you see under Section 35 jurisprudence. Section 35 jurisprudence has unfolded in a way that narrows down the interests of Indigenous people significantly. Aboriginal title, if the Wet'suwet'en pursued this in a Canadian court, would end up putting in the hands of the Wet'suwet'en a Canadian legal instrument called Aboriginal title that would not cover their entire territory. It's just not going to happen. The tests are such that it would pick out parts of their territory, and Aboriginal title would, attach to those parts of their territory. Whereas the UN Declaration just speaks about Indigenous peoples having the right to their territories, period. Those lands that they've traditionally owned, occupied, or otherwise used or acquired. So it's clearly much broader in its vision of what Indigenous land interests look like. And then under 2, I'll just point to the word control. So, in that first sentence, Indigenous people have the right to own, use, develop, and control the lands, territories, and resources. And I'm sure most people who've heard about the UN Declaration know that one of the phrases within it that creates so many problems in Canada is this notion of free, prior, and informed consent. Well, that is an expression used often within the articles. And what it's pointing to is situations where the Crown in Canada would be making decisions about Indigenous lands and would have to get the free, prior, and informed consent of the Indigenous peoples whose territory would be impacted by whatever project's being developed. Here we're looking at something related, but it's from the position of the Indigenous community. The Wet'suwet'en actually have the right to control the lands. They're the ones who should be making the decisions about how their lands are used, which is exactly what the hereditary chiefs are attempting to do. So in the interest of time, I won't dig more into Article 26. You can read 3 on your own. Next, please. And I'll skip over 32.1. It just continues on with this notion of Indigenous peoples having the right to determine for themselves how the lands are developed. But Article 32.2 is interesting because it talks about the states again having responsibilities. So they shall consult and cooperate in good faith with the Indigenous people concerned through their own representative institutions in order to obtain their free and informed consent prior to the approval of project affecting the lands or territories. I mean, this speaks directly to the Coastal GasLink kind of situation. And one of the problems with the BC legislation is that Premier Horgan has indicated that he thinks it only points forward, that it doesn't say anything about things that happened in the past. Well, the approval of the Coastal GasLink pipeline was only about 10 years ago. So we're not looking way back in time, we're looking at the recent past. And if you could take the UN Declaration and apply it to the approval of the Coastal GasLink pipeline, you would look at Article 32.2 and imagine that the state, here the province of British Columbia, would actually have to, in good faith, consult and cooperate with the Wet'suwet'en through their representative institutions, through the hereditary system, to obtain their free and informed consent prior to the approval of the project. So we know that didn't happen, and so I think this is why Premier Horgan would like the BC legislation to only look forward. It still does indicate that things should potentially change on the ground in future cases where other pipelines are being approved, potentially. Next, please. This is, I think, one of the most interesting parts of the UN Declaration. It's Article 27, and I say it's a way forward because it indicates a way out of the mess we're in. I mean, we're in really a stalemate, and we're in a situation where the provincial government and the federal government are not willing to recognize the Indigenous legal and political authority of the Wet'suwet'en people. and the state continues to cling to the idea that it's the only decision maker over lands in Canada. Well, here in Article 27, we see the UN Declaration talking about a way out of these kinds of problems. The state shall establish and implement, in conjunction with Indigenous peoples concerned, so not by themselves, a fair, independent, impartial, open, and transparent process. So some people argue that Canadian courts are fair and impartial. That's certainly an arguable point, but they're certainly not independent. Canadian courts are a part of the Canadian governance structure. Right? They're one arm of the Canadian state. You have the executive branch, the legislative branch, judicial branch. There's no question that Canadian courts are not independent in this kind of situation where you have Canadian law and Indigenous law having some say about how something plays out. So Article 27 speaks to the creation of an independent body that would give due recognition to Indigenous peoples' laws, traditions, customs, and land tenure systems, to adjudicate the rights of Indigenous peoples pertaining to the lands. So this exact kind of situation, Article 27 is saying, should be adjudicated by an independent body, not by Canadian courts. So it's a part of the UN Declaration, again, that is somewhat radical, but it also makes, I think, eminent sense. I mean, this is the only way we're going to imagine a way forward that fits with notions of justice and fairness, having an independent body adjudicate on these matters. And next, please. I think this is the last one. Yeah. So, and just to calm people down, because you know, I've interacted with quite a few people the last few years. People are curious about the BC legislation and the proposed federal legislation. There is something in the UN Declaration that is meant to indicate that the Declaration itself does not in any way envision significant earthquakes that would rattle the status of the nation that's embarking on adopting the UN Declaration. Article 46 says very clearly in Part 1 that there's nothing in this declaration that would authorize or encourage any action which would dismember or impair, totally or in part, the territorial integrity or political unity of sovereign and independent states. So the UN Declaration only goes so far as to try and work out a solution to the problems faced as a result of 500 years of colonial activity in the part of nation states around the world, but it doesn't go so far as to imagine that anything done under the Declaration would challenge the territorial integrity or political unity of Canada. And then Article 3 under 46, or subsection 3, speaks about interpreting the Declaration in accordance with the principles of justice, democracy, respect for human rights, equality, non-discrimination, good governance, good faith, and apple pie. So it's pretty clear that the Declaration is meant to be interpreted in a way that doesn't shake things up too radically. The contents, though, speak about a common sense path forward, which is to simply recognize Indigenous peoples having their own powers of self-determination, their own legal and political authority, and a problem that's emerged over the course of centuries of colonialism that needs to be approached through some sort of collaborative process through an independent body that can deal with the tensions between the Crown and Indigenous legal and political authority. Thank you.
All right, thank you. And Candis, over to you.
Great, thank you. I do. Chocholone hote, tasiden didene de otzi, teskia esta tsei. Good morning, I'm Taltan from the Crow clan, and you're looking at a beautiful picture from Mount Edzaita, which is sort of the heartbeat of Tahltan country. If you don't know where Tahltan country is, you actually have to drive through Wet'suwet'en country to get there. We drive up Highway 36 Highway 16 and turn off on Highway 37 to go up to our territory. So it's really a pleasure to follow Paige and Gordon and to also have Coll moderating. These are three people who've done a lot of work on First Nations issues within BC related to law and history. And I get to bring up the bring up the kicker, as we say in media. So I'm going to talk about media today. My role at the School of Journalism was for about a decade to teach about media ethics. And so I'm going to sort of give you a journalism 101 and shift to ethics towards the end. Most of you know what news is because you read it, feel it, think about it all the time. In fact, it was really great to have Paige and Gordon give you the history and law first, because I usually have to do all that work and then get to talk about media. So I'm happy to dive right in. Next slide. So this list of descriptive words is kind of what scholars have taken news and condensed it down to what we call these news values. If you think about coverage, you've likely been reading lots of coronavirus news. You can think about, for example, when Boris Johnson was admitted to intensive care, right? You've got impact, emotion, prominence, timeliness, weight, right? All of these aspects to a story like that. You can also think, about Justin Trudeau talking about how we shouldn't be speaking moistly as being, both hilarious, but also, kind of unusual and emotional, and a prominent figure saying something like that, right? So, there's many different ways in which you can take the coronavirus stories and see how these news values play out in stories like that. And news values aren't universal. They get applied differently. Next slide. Recently, I was giving a talk in Yellowknife, and I love this picture of all of the covers of local newspapers. And you can see how news values look different in, different communities. These are, sort of hyper-local communities. This is the NNSL newspapers across NWT and Nunavut, and I don't think they don't have any papers in the Yukon, but you can see how this looks different now. Next slide. You'll see how this plays out. CBC, this is the exact same day, how news values are quite different, right? They've divided it into Canada and the world and business, and, Canada, the Canadian stories, you can see that, you have, timeliness and proximity playing a role, because CBC is run out of Toronto. You're not going to see the same kind of stories. But CBC is one of the few mainstream news providers, and it's obviously a publicly funded, publicly mandated news organization to cover the North. So next slide. So that same week that you saw all of those NNSL newspapers, this is what the CBC thought was important out of the Northwest Territories. So every publication and news source has a different way of deciding what's news, but those news values tend to be found in all of the headlines and the kinds of stories that we do. So what does this look like when you look specifically at Wet'suwet'en coverage? Okay, so next slide. So think about these terms when it comes to Wet'suwet'en land defense. And then think about the different sources that you might have accessed when you were reading news. For example, did they use the term land defense, or did they use the term protester? That was a point of contention for many reporters. In fact, I was interviewed by the Toronto Star and explained that land defense was a perfectly appropriate term, given that it represents the long relationship that Wet'suwet'en people have had with their lands, as demonstrated through Delgamuukw, as you heard earlier, and a long history of engaging with colonial state powers, whether they be in BC or in Canada. This was roundly critiqued by some mainstream journalists, and this is something that you have to think really closely about when it comes to covering First Nations issues. So mainstream media we might think of as CTV, as CBC, the Vancouver Sun, the Province, the Globe and Mail, the National Post. And in the last 20 years, as the internet has begun to change all of our daily lives and given us a different daily infrastructure, actually, you see that there's this other, digital set of sources that have come online. We used to call them alternative media, but they also cover, issues like this. And in the case of the Wet'suwet'en land defense, you really saw that the people who were on the ground were from organizations like the Tyee, the Narwhal, which I'm on the board of, and the Georgia Strait was covering it. You also saw Ricochet Media, which is based in Montreal, but they had a Gitxsan reporter who was covering it on the ground. So you really saw the rise of these digital media organizations. So just next slide. And so this is CBC had sent Chantal Bell-Richard, who is a colleague of mine at UBC. She's right now the lead instructor on the reporting in Indigenous communities. She's also an alum of the school and an Indigenous journalist. And she was there, you know, a year and a bit ago when the first RCMP incursion was happening into Wet'suwet'en checkpoints. And then this year, when it happened again, she was in there for a little while, but not the whole time. So really, you had to look to, and if you go to the next slide, you had to look to Ricochet, which had Jerome Turner in there for a while. He was the only journalist behind the checkpoints. As far as I can tell, it's, you know, as a media analyst, you're kind of constructing on the fly and watching as things unfold and stories come out. Next slide. The Narwhal also had a journalist who was reporting and taking photos. The next slide. And the Tyee also had a journalist who was in there. So you can see how the news values played out differently at these different organizations, what they focused on, what kinds of stories were important, and whose voices really came out in each of these stories. But really what's important here is that these, what used to be termed alternative, but I would say digital news sources, were also the ones who were challenging RCMP when they were not letting journalists bear witness. And one of the primary functions of journalism is to bear witness, especially at times like this, where we're watching the state move in on First Nations and others who were joining them in protecting their land. When there's a disagreement about how resource development should take place, this is really where journalism should be doing its most powerful work. Okay, let me just catch up with keeping up with the slides. Okay, and so next slide. And so when we think about how media have changed, this is a report from Reuters. And they do a major digital news report that covers the world. It's one of the few sources we have of what's happening in Canadian media. There was also an older report in 2018 called The Shattered Mirror by the Public Policy Forum in Canada. But I took the Reuters one because it's the latest, and you see how sources of news have changed. You can see how, if you look at the graphs on the right of your screen, you can see that online media, punches well above its weight. Most of us are turning to online sources. TV, then print, and then social media plays a huge role in, accessing obviously online media, but also in directing our attentions. And an increasing role. So you see some decline from 36 to 28, but you also can see that the devices that we're using, have increasingly moved to mobile. If you look at the top social media, and we're going to talk about Twitter, you'll see that it's ranked 4th. It's still behind YouTube, and I mean, I would count Facebook Messenger and Facebook as the same, but they've broken them out. So this is an indication of how much media have changed, which is an important factor, especially in thinking about how to analyze how media have covered Wet'suwet'en land defense. Okay, next slide. And it's particularly important because of the role that social media has played. This is from the US, the Pew Research Center, which says that 2 in 10 US adults get most of their political news on social media. And I would say in these sorts of instances, that might look actually different, and we only have US numbers for this kind of a statement. But in something like the Wet'suwet'en land defense, you really saw that it was digital media playing an outsized role. And I would argue that one of the defining differences, perhaps, you know, even more than any other previous protest, is the ways in which you could get statements directly from Gedemden checkpoint and from Unistaten checkpoint, right? So you could, or the Unistaten encampment, you could go on Twitter and get statements directly from Wet'suwet'en voices. And I think this is really sort of an important moment in thinking about both how media cover, but also the kinds of direct access that you have as a result of these platforms. Okay, so I'm going to give you a deep dive into Twitter in particular. This is like research on the fly. We use this tool, you can go to the next slide, called Crimson Hexagon, which is a really interesting tool for looking specifically at social media coverage. So this is a word cloud based on about 457,000 posts. And so you see the kinds of words that are popping up to the top, and you see the kinds of people, you know, you see Horgan's Twitter handle, you see Pam Palmetter's Twitter handle, you see Sean Carlton, who's a historian who tweeted a lot, right? So you see the ways in which, you know, different issues begin to pop up. Next slide. And you also see the peaks and valleys, right? You see the ways in which in most of January, this was kind of a quite quiet issue, and then it begins to peak, and almost 1 million posts, right? And then you see the ways in which COVID-19 has literally taken over all of our lives, materially and in relation to news. Next slide. But what's super interesting for me as a keen analyst and watcher specifically of something like Wet'suwet'en, because, you know, as I've said in media interviews, BC First Nations owe an enormous debt, as Paige and Gordon have both explained to you, for the work that they did around Delgamuukw, which, you know, all of us look to these cases as a way to explain our rights and to explain our situation in Canadian and specifically in this province's history. So if you look at the most influential Twitter authors, guess who they are, right? The top two are Unistaten and Gedemden, and they actually come out above Justin Trudeau and John Horgan. And Ricochet Media is also, you know, in the top 5. Now, how many of you know what Canada Action is? Likely, if you were paying very close attention to your Twitter feed at this time and paying close attention to Wet'suwet'en in particular, you would have seen a lot of these sponsored ads pop up a lot. And then you would have started seeing them retweeted. Now, Canada Action seems to be an organization that is very pro-pipeline, and it's not clear exactly where their funding is coming from, but they certainly were very interested in countering a lot of the messages around land defense. Next slide. And you can see that their tweet actually was the top retweeted tweet from all of the tweets that went on. And in fact, 2 others of their tweets occur in the top 10 retweets. So retweets are super interesting for me because my colleague Alf Hermida, who's the current director of the School of Journalism, and I did a similar Twitter analysis during Idle No More. And during Idle No More, it was super interesting because what you were seeing in mainstream media, so the CBC and CTV and Globe and Mail, were mostly non-Indigenous people analyzing and speaking about, and in some cases for, Idle No More. Whereas if you went on Twitter, it was almost all Indigenous voices, right? The top retweets, what people were saying that was being, that was resonating with those who were paying attention to it was being retweeted. And so, Greta Thunberg is one of the, top retweeters. Obviously, she has a global audience. So that Canada Action ends up above her is kind of interesting. Next page. You can see, sorry, Jesse Wente is at the is the 6th. Another person called Citizen Yan. So these would be people who already have large followings. Jesse Wente, if you don't know him, is a Anishinaabe. I guess he speaks a lot to the media, but he's also head of the Indigenous Screen Office, which I'm also on the advisory council for. And so then you see the last of the list, Jesse Winter, a journalist, and the Canadian Association of Journalists, which was the first, this was among the first tweets to really signal that also there was some suppression of media and media freedom going on around the RCMP incursion into this checkpoint and the encampment along the Morris Service Road. So, it is interesting that we had alternative media, likely with thinner pockets than mainstream media, as the people who ventured down the Morris Service Road. If you're from British Columbia, you know that these forestry service roads are throughout our province. They're created by mines and by forestry companies and branch off into our territories. And, they do require some, a good car to get down them. Often a 4x4 is really helpful. And yet it was alternative media that was getting their reporters into the checkpoint, talking to Wet'suwet'en people, making sure that they were there when RCMP, began dismantling Unistoten, for example. Okay, so next slide. So I just want to go back a little bit to journalism so you understand that journalism is not only kind of beholden to these news values, to what we determine to be news, but it's also beholden to forms and styles. One of the most stable aspects of journalism, even as we've watched online media kind of upend economic models, upend a lot of journalism organizations, and upend our daily habits, one of the most stable aspects is this thing called the inverted pyramid, which is what you're looking at. So the first line in a news story is the lead, right? And usually within the first 2 or 3 paragraphs, the next thing is called either the nut graph, I guess it's sort of like it has to answer the reason why you need to read this story. And basically, news organizations line it up in terms of what you as a reader or a watcher or a user might consider to be the most important details down to the least important details. And I actually do a exercise usually with students where I line up a very simple news story and say, okay, well, which details do you think are the most important? And it's super interesting to realize that we all line up details differently, even journalists, even journalism students, right? And so I want to go to the next slide. And so if we look at a news story, so this is a news story from the Narwhal. Stephanie Wood is a Squamish journalist and recently hired by the Narwhal and an alum of the UBC School of Journalism. So I'm giving you examples of journalists that I follow and that I think are doing good work. And you can see that her take on this story is about how this could have been done differently. So her lead is dozens of arrests, a week-long raid on Wet'suwet'en camps, grainy videos of armed officers, doors blocked at the BC legislature, railways stalled across the country. So that's your hook, right? That's the reason why you're going to pay attention. Wow, all these things happened. For a conflict that began in a remote place, the impacts of the Wet'suwet'en hereditary chiefs' opposition to the Coastal GasLink pipeline are now reverberating across the nation, right? So there's your nut graph that tells you why you need to keep reading. And then her major question is, as tensions flare and politicians seize on the moment to criticize their adversaries, one has to ask, was this escalation inevitable or could it have been avoided? Right, so these are the kinds of questions you're not necessarily going to see in mainstream news. This isn't a story that you probably would have seen in the CBC or on CTV or in the Globe and Mail. The Toronto Star did some good reporting. Certainly you can't make blanket statements. But if you were paying attention, you know that I was definitely attacked by a Vancouver Sun legislative columnist because the Georgia Straight wrote about it. That's the only reason I have to mention it. And you know, because there is a lot of debate about how this should be covered, about how Wet'suwet'en people should be referred to, how about how non-Wet'suwet'en people who are supporting the actions in Wet'suwet'en country should be referred to, right? So, so this story, you know, provides us with a really, you know, a pretty good example of how the inverted pyramid works, but also as an example of good journalism. And what you may not know if you're not working in journalism is that the headline was not written by the reporter, right? The editor writes the headline. So in some cases, that's why you end up with, you know, mismatches between maybe the intention of the journalist and what the editorial part of the publication, you know, wants to see happen, or, you know, what they're invested in, or what they think the audience will be interested in, or what they think the story is, right? Okay, so next slide. And I want you to be mindful of this, that what happens in First Nations coverage doesn't just happen to First Nations. Michelle Gosub is a alum of the school and also a working journalist. And this is honestly one of my favorite tweets. She probably doesn't realize I use this all the time. But I mean, you know, imagine confidently typing this and not seeing any problem. And this is from a New York Times story. The Middle East could use a decent country. It right boggles the mind. Next slide. The Washington Post got in a huge amount of trouble for the way that they headlined an obituary for Abu Bakr al-Baghdadi, who was, they called the Islamic State's terrorist-in-chief. I mean, you know, then they changed it to austere religious scholar at helm of an Islamic State, right? So you can see the ways in which the language media uses is really important. It's not inconsequential to call a protester a land defender, or a land defender a protester. One of the first articles I wrote when I came back to working in journalism in a journalism school after I got my PhD was about the differences between calling someone a freedom fighter and a terrorist. Right? Those are two really different terms, and tell you everything about the, you know, the position of publications in some cases, right? And I'll get to talking a little bit more about that. Okay, next slide. Let's speed up a little bit here. Oh yeah, so then a lot of people had a lot of fun with the headline that the Washington Post put on, right? Osama bin Laden, father of 23, killed in home invasion. Right, Saddam Hussein, successful politician, oil baron, and noted tough boss, dead at 69. Right, so how we frame, right? If you've heard this term, right, the cognitive shortcuts that we have for, you know, public figures become very important when you apply those to news values. So newsworthy people are often prominent people. We have cognitive shortcuts for them, and likely lots of cognitive shortcuts were developed during the Wet'suwet'en land defense coverage as well. Next slide. So where this falls into is ethics. Sorry, next slide. I'll just keep going until all the words are in there. So what this falls into is, you know, is in the bin of ethics, right? Ethics are really the professional norms and practices of journalists, which are, you know, really a lot different than law, right? Law provides us with a hard line if you do something that the law considers wrong, like libel and slander. If you know, steal somebody else's work and pass it off as your own, we call it plagiarism in academia, but you know, this would be copyright infringement in some cases, right? So there's a law in Canada which requires journalists to, if they're going to make an accusation, give the person they're accusing a chance to speak back. That's called responsible journalism. But all of these other things, right? The framing, how we convey a story, what we think is the story, those fall under the bin of ethics. And so this list on the left is telling you a little bit about, you know, all these different, you know, sort of big ideas when it comes to ethics. And they're all basically decided on by journalists themselves. Next slide. right? Stephen Ward, who is the former head of the UBC School Journalists and a noted ethicist, he says that journalists appeal to ethical norms as part of a strategy, a rhetorical strategy to defend their practices. The aim of editors' ethical rhetoric is to establish, maintain, or enhance their own credibility and that of their publications. So actually, journalists tell you what they think is ethical, then tell you that they've done something ethical, and they also set the ethical rules. So, you know, in some ways, it's a bit of a virtuous circle, which is why it's so important that social media allows us a platform to call them out. And it's not as if, you know, some of this stuff isn't enshrined in different, codes of ethics. Next slide. The Society for Professional Journalists has a code of ethics that we teach with. Next slide. You know, it basically conveys these main points, right? That journalists should seek truth and report it, but it doesn't necessarily say whose truth and what do you do if there's multiple truths. Harm is a relatively new concept within journalism ethics and within the practice of journalism, where, you know, journalists have begun to think about harm as something that has occurred in the past. And obviously, we rely on journalists to act independently and to be accountable. Next slide. The CBC has its own tailored standards and practices. And so this brings me to talking a little bit about this book that I just finished writing with my colleague, Mary Lynn Young. And you can go to the next slide. It's called Reckoning: Journalism's Limits and Possibilities. And what we do is we try to go beyond just questions of what's ethical or what's not ethical, and really try to understand how journalists know what they know, right? How is it that journalists form stories? Who gets to decide what good journalism is and when it's done right? And what sort of expertise journalists have? What role should they be playing in society, right? So these are the primary questions of our book. And in some ways, we build on another book. You can go to the next slide, which some of you may have encountered. And I thought it was hilarious when I was getting a screenshot of the book. My little review is right at the bottom. So you know what I think of this book. I've taught with it since it came out. I was really excited about it coming out because it was really one of the first histories of how media have covered Indigenous issues since pre-Confederation, since the beginning of media here. So whilst we have this nice list of ethics, and journalists tend to think of themselves as being independent, as being accountable, you really see, when you look at Seeing Red, as sort of grand march through a history of media in which Indigenous people have been found as wanting morally, ethically, legally, physically, and the ways in which media have absolutely propped up colonial narratives. And you see that even in Paige's presentation, where media of the day were absolutely supporting a particular view of Indigenous people. They tacitly supported doctrine of discovery, tacitly supported the colonial state, putting Indigenous people onto reserves. This is perhaps one of the most important things to remember, is that media are, absolutely an institution within a colonial context, and they operate within that colonial context. This is something I often feel like I talk about, like a broken record, on the podcast Media Indigena that I'm part of, that Rick Hart produces. And I'm often on with Kim Tallbear, who I'm going to quote in just a second. So next slide. One of the underlying concepts within Seeing Red, and which underlies as well the book I've written with Mary Lynn Young, is this concept of settler colonialism, right? And I often like to put the definition up because I think that it's often forgotten what it's really about, which is that it can't be reduced to, the unfortunate birth pangs of a country being born. In fact, it is a structure that's been set in place. It's not only about events, although events become important ways of talking about it. In fact, it's a persistent social and political formation. And it's about dispossessing Indigenous people of the land and disappearing them. Really, that the value of this concept and this framework is in understanding that that is still ongoing. And that media in some ways participate in it. in very problematic ways, and it becomes especially visible around coverage of something like the Wet'suwet'en land defense. Okay, next slide. And you know, in the book we talk about this article in particular because National Geographic was, you know, actually hired a historian, which is sort of funny, to tell them that their coverage was racist. Next slide. And what Kim Tallbear pointed out on Media Indigena when we discussed this is that these narratives have not really moved a lot, right? They just get recombined with multicultural, let's all get along, we're all related. But these old school race narratives are still very much a part of the way that people in Africa, people in Pacific Islands, people in Indigenous North America are also, and South Indigenous Americas really are often portrayed, and it hasn't moved a lot. Next slide. And yet here, I think, is something to really think about, right? I hear from readers that National Geographic provided their first look at the world. For how many people did Wet'suwet'en coverage provide their first look at what was happening in BC, or what was happening in Wet'suwet'en country? And I think this is the major responsibility that media really still have in terms of not reinforcing existing social order. Why didn't media ask how it is that UNDRIP is not being used as a mechanism in this situation? How come UNDRIP being passed several weeks before Wet'suwet'en land defense, you know, reached its peak with RCMP enforcing an injunction for a corporation? Why is it that media didn't ask important questions about UNDRIP and why it wasn't relevant to this situation? Next slide. And, you know, media have changed. A lot of my journalism students who get, you know, really depressed when I do presentations about how Indigenous people have been covered and after they've read a book like Seeing Red. And we have seen some coverage change, and we have seen Indigenous journalists in particular playing a really important and transformative role about how journalism is practiced. And this is a quote from Tanya Talaga, who said, you know, she's a 20-year plus journalist for the Toronto Star and became a columnist, is now working independently as a filmmaker and as a journalist and writing another book, right? You would know her from the Massey lectures if you heard her give those. And she said, you know, before Idle No More and the Truth and Reconciliation Commission, thoughtful, fair, non-racist reporting on Indigenous issues was hard to find. This is from a working journalist. And, you know, one of the big differences that Indigenous journalists bring to a story when they cover it, you know, you could also see it something like Standing Rock. Go to the next slide. This is a picture of Jenny Monet, who was a journalist who is Indigenous and was arrested with protesters at Standing Rock with water protectors, right? It's the term that came into use there. And what she said when we interviewed her for our book, next slide, was that what I've been trying to instill in a lot of the conversations that I have when critiquing media and its approach in covering Indian country, which is very a term that's used a lot south of the colonial border, is that the historical narrative is just as important as what's happening on the ground, right? And I think this becomes really important when you consider an issue like we've been discussing this entire time, right? The kinds of historical frameworks that come into play become, you know, vital to understanding what's happening when RCMP are, you know, enforcing an injunction, when they are preventing Indigenous people from having a healing center, right? So historical narratives must be part of the story, and yet for most journalists, if they're my age, they didn't grow up with any kind of history in their school, right? I think about myself as an Indigenous person. I've had to self-educate primarily. I finished college in the early 90s, actually while the Oka crisis was going on. And for me, the thing that has been really fascinating is watching my high school age daughter having to have the same conversations that I had in my college years with her classmates, having to explain what, you know, where Indigenous rights come from, that there is a legal basis for them, that there has been a continued pushback on them from media, from their education systems that have not necessarily educated people any better, I think, this is my personal experience, than they did 20 or 30 years ago. And I think things are getting better. You know, my kids have learned a lot more positive stories about Indigenous people, but there's still sort of such a base lack of education about all the things that we've been talking about today. So I'm just gonna skip to slide my 38. There we go. And I'll just close with this quote from Rick Harp, who is the producer of Media Indigena, this podcast that I've been working with for a while. And you know, he points out that for Indigenous people, stories literally can be life or death, and that the status quo is literally deadening and destroying the lives of Indigenous people, which means that if Indigenous journalism is to be of any service to Indigenous peoples, it must critically engage the status quo. Next slide. Lately, I found myself wondering whether Indigenous journalists ought to regard their work as that of war correspondents. Indigenous lands, Indigenous waters, Indigenous bodies, even Indigenous languages, all are under constant attack in forms both overt and covert, proximate and distal. Think I'm being hyperbolic? Talk to the people at Standing Rock, talk to the Indigenous journalists who were covering it. How then does a journalist cover a people, their own people, in the face of such relentless existential threats? Somehow the media convention of let's hear it from both sides of the story just doesn't cut it. And I think this is the real difference that Indigenous journalists have been bringing to this story, and others who are well educated about the history of Indigenous people and the history of how Indigenous people have been covered. And that is, they bring a sense of history. They bring a sense of accountability. They set themselves as not necessarily objective. They might use objective methods, but they recognize that they have what my podcast co-roundtabler Kim Talbert says is mud on their feet from somewhere, right? Which in academic terms, we would say you have situated knowledge. Your knowledge comes from somewhere, and that even applies to journalists. Okay, so I'll leave it there and open it up for Coll to lead us.
Great, thank you. Thanks, Candis, and thanks, Gordon and Paige, all of you. We have a few questions from our audience, but I wanted to ask a question first to kind of bring all three of you together a little bit. And that has to do with the global context of all of this. You've mentioned Standing Rock a couple of times, Candis, and some other instances have come up as well. And so I'm thinking about Standing Rock, I'm thinking about Ihumatao in Aotearoa, New Zealand, I'm thinking about Mauna Kea. And how do you, the three of you, see what's happening with here in British Columbia as part of a larger global pattern, historically, legally, in terms of media coverage? Is there a global story here at the same time that the Wet'suwet'en story is also an intensely local one?
I mean, I'll go first. I mean, I think definitely. I mean, I think that the ability of Indigenous defenders, whether it be land or waters, to speak directly, to speak on their own behalf has been a transformative aspect. I think Indigenous journalists have been a transformative aspect. And, you know, and yet I still think it's really slow going. I think it's hard for an issue like Mauna Kea to get on national media radar. Similarly, you know, with Standing Rock, national media were very slow, late, and had a lot of problematic coverage. There was some good coverage too, but you really see how important Indigenous media and diverse alternative media that are very committed to you know, decolonization, like Ricochet Media, they explicitly say in their mission statement that they are committed to decolonization. So I think there's enormous connections when you look at social movements and media. I don't know more being obviously a big example as well.
Paige or Gordon, did you want to respond to that question at all?
I don't know if do I put my hand up or just speak? Good, okay. Well, I agree there's a larger global context within which this all fits, but just to give a short answer to the question without getting into all the different ways in which there's this larger picture, there is an actor on the global stage that we haven't really talked about yet, and that is the emerging transnational corporation. I mean, there is a thing going on the global level that Indigenous peoples face around the world, and it is this actor that doesn't really respect national borders, doesn't have to respect national borders. It's been set up in a way through international law so that it can transcend borders, but then it moves around the world and impacts on Indigenous peoples in different ways. I would say that, you know, given that, there are definitely stories around the world that need to be told, but they also need to be told with some particularity. And so focusing on the Wet'suwet'en, I think, is important, and on BC, because as much as there's other stuff happening around the world, you know, there is a particular nature to this account, this story.
Yeah, I would just maybe add that both historically, we could just as easily have had slides that I showed that looked at Indigenous peoples globally and their history of asserting their rights against empire. So if we have multinational corporations as the actors today threatening Indigenous peoples' ability to exercise sovereignty, we previously had imperial actors doing that. So, and we've seen Indigenous peoples trying to build those global international connections since, at the very least, the 1970s, in order to make that case and to highlight the global significance of it. And I guess I also see anything that's climate change related has to be a global story as well. So it's sort of, there's intersections of these two global issues in the case of the Wet'suwet'en here, both the climate change issue as well as the international perspective on Indigenous rights that the declaration that Gordon focused on brings forward.
Great, thanks everyone. I'd like to take a question, riff off of a question from one of our viewers, from Melanie. She asks how, if the three of you have any advice on how we could speak to people about how the doctrine of discovery is embedded in the legal system. And maybe a broader question is, what strategies might the three of you suggest for people trying to speak to a broader audience, to a broader public about these questions? Are there any particular strategies that work really well, whether it's about the doctrine of discovery or other aspects of this?
I think I should probably jump in there. I saw the question before I began my presentation and tried to address it somewhat in the middle, but didn't get into it in great detail because it's a complicated picture. There's no discussion of the doctrine of discovery in Canadian jurisprudence. Canadian courts stay away from it. On the other hand, the Canadian legal system is built on it because it arises from the assertion of Crown sovereignty at different times across Canada in different places. And how, you know, Paige mentioned this, I mean, it's a bit confusing. It's a mystery. How did this happen? In BC, for example, it's just entirely mysterious. How did the Crown get sovereignty? It asserted sovereignty, certainly, but how did it manage to find itself in a position where it could make all the decisions about what happens in relation to land and water and air and everything else in the province? And it comes from this notion that developed in other legal contexts. It was actually developed by an American judge in the 1820s and 30s. This notion that imperial powers could interact with Indigenous peoples where they discover them and determine the nature of the relationship. They would unilaterally decide how they would interact with that Indigenous community, whether it was Australia or parts of Canada or the United States, whatever. And at the heart of it also is this notion that this makes sense because the European power coming to that relationship would be superior. I mean, there's this, I showed you that bit of the preamble, the declaration, because, you know, it touches on that kind of doctrine. That's a fundamental doctrine around the world. This notion that European powers came to places that weren't Christian, that were pagan, that had other forms of governance that they didn't recognize. And their mindset was that they were coming to enlighten people, to civilize them, to Christianize them. There's so many deep racist beliefs built into that picture. And that then justified the imposition of sovereignty over these people. So they thought, well, this is something they're gifting to people. We're allowing you to become parts of our community, even though we never let you become an actual part of our community. So there's all kinds of ways in which the doctrine of discovery emerges in the legal systems in the West. And then it definitely does sit at the heart of Canadian law, because Canadian law and Aboriginal peoples doesn't question the notion that the Crown gets to make all the decisions about Indigenous lands and peoples.
Does anyone else want to speak to the question at all?
Oh, go ahead, Candis.
No, go ahead.
So I would just say that I also heard that question a little bit as being about strategy, and that one of my strategies is one that I tried to model today, which is to try and get people to feel surprised and to be like, what? You know, as opposed to, oh, this is the status quo and isn't it too bad, but it was inevitable, or that in fact it shouldn't have made sense even at the time, and that we should see this as a problem rather than the taken for granted status quo. And so trying to flip things around or think about analogies, and there's plenty of more extended explanations of these out there now as a sort of storytelling device. What would it be like if a guest showed up in your house and you invited them in for dinner? Then they said they were going to spend the night and you didn't kick them out. And then they decide to tell you you have to live in the basement and they're going to take over the main part of the house. But those types of, I think, ways of flipping the story from how we're used to hearing it, I think is useful at getting people to unsettle the assumption that Gordon was really working at unsettling, which is that Canadian law is the box within which Indigenous rights have to sit. And we've seen, as he pointed out, how limiting that box of Canadian law has become, and that the way of looking for justice for Indigenous peoples lies outside of that with Indigenous law or with other practices. So that's my strategy anyway for trying to explain those things, is to, some of my students I know are former students are part of this webinar, and they've all seen that cartoon I started with the ship and the explorer shouting mine. They've seen it dozens of times. I use it over and over and to sort of to illustrate many different points.
Yeah, I mean, I would just echo what both Gordon and Paige have said, and to recognize that you're often in public settings that most people don't know that there's a long history of resistance. In fact, when I first began doing my crash course in BC history for journalism students and ethics, I would tell it in three registers, right? One is the long history of activism. The other is the long history of legal claims. And then the other is more the cultural evolution that has happened alongside that. And so, you know, I think you have to recognize that there's different ways of telling the story, but at the same time, you know, there's such a lack of knowledge, of base knowledge.
So I have a question from Chantel, and she asks, in thinking about these UNDRIP articles that clarify the authority of Indigenous political institutions, how do you see this playing a role in co-management relationships regarding parklands or, quote, resources? How do you see braiding these legal orders, to use the language of John Burroughs, as a possibility?
Okay, I'll take a swing at that, but I mean, obviously it would be the way things should be done. There should be some notion of co-management that actually adds some substance to it. And there are places in Canada where there have been agreements that are approaching that kind of model of actual co-management. But the general picture in this province has been of a term that arrives on the scene and gets people excited, and then it gets co-opted by provincial and federal governments. And you wind up with these co-management agreements where the Canadian side of it actually determines, you know, what the negotiations will be about, what the framework will look like, what the standards will be that apply in the situation. And so it ends up being more a matter of Canadian system that is indigenized in some form or other. We get Indigenous participants in it. So we need to move past that. We need to get into something like substantive co-management. And again, there are some models in Canada where people are pushing things in that direction. There is some stuff under the UN umbrella, the Yukon umbrella treaty that was established in the early 1990s. And then the Yukon First Nations work under that umbrella agreement. And they've been able to do some stuff there, for example, that gets close to this model. And that is what the UN Declaration is envisioning, because it just makes sense that if you have Indigenous peoples who are in an area and then the Crown comes in some mysterious fashion, takes control, that just doesn't make sense. And the only possible outcome, given that the Crown is not going to leave, and this is where we're at, is to have the two different authorities work out some sort of a process of agreeing on how they're going to manage an area.
You know, the other thing that I would add to that is that there's such diversity among Indigenous peoples about what their aims and concerns and management frameworks are, like what their traditional ways of thinking about land are. And to me, this is one of the really big challenges of both law and media, is that both want to treat Indigenous people as the same, or, you know, make some sort of generalizable rules about, you know, Indigenous issues, or in the case of media, how to cover. And I think that each you know, issue, situation, land relationship needs to be considered as individual. And I think that that's not the way our society is set up. We might be able to make more flexible categories, but we still want to hold on to this category of Indigenous.
Lawrence has a question where he wants to learn more about Wet'suwet'en laws, and can any of you direct us to resources where we might learn more about that piece of the story?
I seem to be the one jumping in at the beginning here all the time. No, I saw a number of comments like that in the chat section and in the questions, and I fully agree with the position of a number of people who've asked, you know, what is it in this teaching that talks about Wet'suwet'en law? And I've avoided that. I avoided my presentation. I pointed to the fact that there is Wet'suwet'en legal authority, but I'm not an expert in Wet'suwet'en law, and I don't ever imagine myself presenting myself that way, because that's not appropriate. So are there resources? Yes, but I think the first thing to do would be to go and discuss this with people in Wet'suwet'en. A number of the people in the chat, for example, are Wet'suwet'en, and you might ask those people, who would you recommend talking to? You should really talk to people first, and then they would get, you know, at some point maybe give you some physical sources, you know, books and stuff like that. But people tend to be the sources of Indigenous law. Who the right people would be is this thing you need to develop a relationship in order to find out about.
Yeah, sorry, go ahead.
You go this time.
Yeah, it reminded me of something I wanted to touch on a little bit too, and that was the way in which media continually covered Wet'suwet'en communities as divided. And certainly, if you're from an Indigenous community, there's always divisions, right? There was something that just seemed so unfair to me about it being trotted out the way it was, as if that was somehow special or different. When you think about communities that you're part of, if you're not Indigenous, there's also always divisions. It was interesting. I was on a Al Jazeera program with Molly Wickham, who is from the Wet'suwet'en people, and another academic, Sherry Pasternak, who's with the Yellowhead Institute. And of course, they're going to ask that question about divisiveness. And my answer has always been about, that communities have shared concerns. Like, we need to work from the shared concern place, especially when we're not in the community, and they need to work out their own, how they prioritize and speak about those concerns. And I think that, this is a real challenge in coverage, in particular in this situation, but it's always a challenge, right? if you looked at the way Mauna Kea was covered, you saw the same kind of divisive edge in the way that media covered it, instead of recognizing that there was a lot more shared concern about community survival, right? About survivance, about collective continuance, use all these Indigenous studies terms. Sorry, go ahead, Paige.
I was just going to add on to what Gordon was saying, and I see lots of people in the chat are mentioning Antonia Mills's book, The Eagle Down is Our Law. And just to connect that to some of the comments we've made in our presentations, that book is the result of Antonia Mills's expert testimony for the Wet'suwet'en during the Delgamuukw trial. And so she's an anthropologist based in northern BC. And so one of the remarkable things about the Delgamuukw trial was that there was an extended period during which Wet'suwet'en elders and these legal experts, who, Gordon, the people who hold that law and hold those Indigenous legal traditions, spoke to the Canadian courts in an extended fashion at trial. So I suppose for somebody who really wanted to get into it, they could look at the trial records, but also these expert testimonies were also presented by academics, and those would be some textual places people could go to look. But I would encourage people to look, again, not just at the scholarly testimonies on that, which are the ones that the court tended to prefer to hear from, but to think about ways to access the testimony that was given by those elders, which the trial judge then dismissed for the most part.
If I could put a quick plug in too, sorry, Paige, no, well, hopefully you hear me. UBC holds the archives from Delgamuukw Gizdewe. Gary George was saying that we should say as well, besides Delgamuukw, that Gizdewe was the Wet'suwet'en name at the top of that case, and that's an important point. But UBC holds the archives for that case, for the transcripts, the background documents right now, and it would be wonderful if there were some way to gather money to get that digitized, because we're talking about a room full of material. We're not talking about a few binders, we're talking about boxes. I think it's 80-some boxes of material that were gathered during that time. And it's a rich resource. I'm going against what I said a few minutes ago, and I said, talk to people, but if you're going to go to a physical resource, I mean, that's an incredibly rich source.
So we're just coming to the end here. So Kara has a question that actually ties it into the fact that we're having a webinar rather than an in-person event. And she asks how COVID-19 is currently affecting the coverage for Coastal GasLink and what is currently happening in Wet'suwet'en territory. And is this situation dangerous? The only coverage she's found is directly from social media at Gidimt'en and Indigenous youth. But how does our current context perhaps shape what's happening now or what might happen in the near term?
Yeah, I was surprised to not see more coverage. I mean, there was certainly a few stories. And again, we're seeing digital media playing much more of a role. It's digital media sources like the Narwhal and the Tyee that made the first connections to MMIW and what was happening, in February, and again, making the connections now between man camps operated by CGL and, continued RCMP presence. So there hasn't been, I would say, a lot of big coverage, and I think this is the challenge and why I started with news values in a way, because what both mainstream and digital the sources formerly called alternative struggle with is what their audiences are interested in, and many of the stories have veered towards, well, is this bringing us all together, or like everybody's learning to make bread, and instead of the real racial differences that are causing the differences in death rates and how those are structural. And so to me, that's the story that needs to be told here too, that this is a structural, historical issue, right? We need to understand why it is that Wet'suwet'en communities are at greater risk because they have man camps, and why those man camps are there, and that it's connected to these stories that were top of mind in early February. So, but that hasn't been happening, and I hope that we'll see, at the very minimum, sort of more coverage from digital news sources. But it's like an op-ed that's been rolling around in the back of my head as well about this, because I think COVID coverage has eaten up so much, and yet we're not getting to those bigger stories that that really actually the ways in which our worlds are being reshaped, both by the fact that we're having this webinar, not an in-person conversation, and by the fact that communities are under greater threat.
Well, that brings us just about to 11:30. I want to thank everyone who's been adding links and resources in the chat. Hopefully people can check some of those out. Obviously, this is an ongoing conversation, and thanks to the literally hundreds of you who showed up to listen today and to offer questions and resources. Thanks to Candis, to Gordon, to Paige. Also, thanks again to our sponsors, the First Nations House of Learning, the Office of Equity and Inclusion, and the Learning Circle, and of course to our Musqueam hosts in whose territory we are working. So I will thank everyone now, and I guess bring it to a close. Thank you so much.
Thanks, Coll.
Thanks, Coll. Thanks, everyone.
Thanks, everybody. Thanks for all your questions and comments.
Mm-hmm.
Be well, everyone.